Next, we're going to look at investigation and prosecution of computer crimes. We'll look at types of evidence and evidence handling. Again, this is a huge area of test worthiness on the exam. There are some inherent barriers or difficulties in the investigation and prosecution of computer crimes. One of the first we deal with is the jurisdiction issue, and that is who is in charge of this crime. Because while the server might live in Texas, the attacker might live in China. Who's got jurisdiction on this crime? The general rule of thumb on this is if the victim and the attacker are both in the same state, you contact the local police. If they live in different states, you contact the FBI. And if they live in different countries, you contact the Secret Service. Another barrier is that law enforcement agencies are undermanned in this particular arena of skill. There aren't enough qualified, talented individuals relative to the investigation and prosecution of these computer crimes. It takes a great deal of skill, it takes the latest tools, and it can take a great deal of time to investigate and prosecute these computer crimes. Further, laws may not exist to protect against a particular crime. It hasn't occurred before, and as a result, the lawyers, the lawmakers, haven't had the opportunity to actually produce the law that protects the individuals against these crimes. Companies also don't like to report these crimes because it shows that they have been unable to adequately maintain the security of your confidential information. So they don't want this information to be known, the fact that they've had a violation, and they don't report the crime. More and more often, it's against the law for companies not to report these crimes. So while they get attacked and have a crime inflicted upon them, they also very often become a criminal in that they haven't reported this crime as they are supposed to. Another barrier is that the evidence is very difficult to collect, and it's also intangible. It's hard to maintain the integrity of this information and be able to convince a jury that this magnetic impulse on this particular location on this hard drive means that the bad guy actually did the bad thing and therefore should be convicted. So this is a very difficult thing to convince a jury of, this very intangible type of evidence. And then further, many lawyers are very often not skilled in this particular and highly specialized arena of law. While we might have the police support on our side, perhaps in our state or our country, the police support on the other country very often will not cooperate. They don't see it as a crime, and as a result we get little to no cooperation on these trans-border issues. We have different legal systems, different rules of evidence in different jurisdictions, and these are often problems. Evidence rules differ between the legal systems, jurisdiction issues, and again, governments may not be interested in helping one another relative to these crimes. So two different organizations that help us prosecute are the G8, which have agreed to cooperate and help fight cybercrime. G8, of course, being the group of eight, the eight industrialized countries, the largest 8 industrialized countries. And then Interpol, of course, is the International Police Organization. And again, these organizations will help us fight cybercrime in a worldwide level. To help standardize evidence and jurisdiction issues, a document has been prepared called the Generally Accepted System Security Principles, and this is a byproduct of the Organization for Economic Cooperation and Development. It outlines the general rules of how we should implement security internationally so that we can standardize on rules of evidence handling, evidence collection, what is against the law, things along these lines. So this is an international attempt at standardizing some of these concepts so that we can prosecute cybercrime on a global basis. The next thing we need to consider is how do we identify when a crime actually has been committed? Just because something peculiar occurs doesn't mean it's necessarily a crime. It could be a misconfigured device, it could be a user error, it could be some application that's gone awry, gone astray. So we generally should have one or a few security professionals that are authorized to declare an incident, a criminal incident, because the declaration of this incident warrants a great deal of investigation and cost to the company. So once we identify that the crime has occurred, we now will be committing a great deal of expense and time and manpower to the investigation of that crime. We also don't necessarily want to call the law enforcement into the situation too early. If we call law enforcement into the situation prematurely, we might just discover that it was a faulty network interface card that was causing the denial of service attack on my routers. It wasn't a true criminal act. There was no malicious intent. It might have just been a misconfigured or a failing device. Also, when we bring law enforcement into the equation, we now lose control of the investigation. They will acquire evidence and take it away from our possession. In other words, the server that was victimized in the attack now is a piece of evidence. It must be protected by law enforcement so that it can be used in the prosecution. And that means that the server that we relied on for our services is now no longer part of my property. I don't have access to it. Now that device will be returned to me after the court case has been settled. However, that could be years before I get it back. So this is always a big consideration. Further, law enforcement is concerned solely with investigation, identification of the criminal, and prosecution of the criminal. They don't care about a company's reputation. This is not their primary concern. In other words, your reputation may be damaged because law enforcement makes this crime public knowledge. And when the public learns that you have been violated due to a security breach, your reputation now is damaged because the public no longer trusts you to protect the confidentiality of their private information. Another issue regarding law enforcement participating in your criminal investigation is that they are subject to a higher standard of search and seizure rules. They have to comply with the Fourth Amendment that protects against unauthorized search and seizure. They are required to obtain a search warrant from a judge before they are able to acquire evidence from the suspects. However, as a citizen, you are not subject to that higher level of law regarding search and seizure. So there's a thin line here. If law enforcement advises you that you need to acquire that hard drive that you think is in the briefcase being stolen by one of your employees, if they tell you to get that back, you are now acting as a police agent and you are now subject to that higher standard on search and seizure. It is against the law for you at that point to take away the briefcase, open it up, and reclaim the stolen hard drive. However, if you are acting on your own behalf as a citizen and you snatch the briefcase out of the employee's hand, take your hard drive back away from them, this is not a violation of search and seizure law. So there's a thin line here between behaving as a citizen and behaving as a police agent. You need to understand the difference between those two and act accordingly. During the investigation of a crime, police will be looking for motive, opportunity, and means. Motive is an indication of why someone would want to commit this crime. Opportunity is, did they have the opportunity to commit the crime? And means, were they capable of committing the crime? We'll next look at evidence, and this is, again, a very large portion of the exam, so this is an area you want to be sure you understand. Evidence is used to prove the truth or falsity of a statement. It can directly implicate the perpetrator of a crime. In the case of computer crime, it can be very intangible and hard to gather, and then hard to convince a jury that this particular piece of evidence actually indicates that the perpetrator truly did commit the crime. Evidence has to be material. It must be competent, which means it had to have been obtained legally. And again, remember the Fourth Amendment regarding search and seizure. And then we also have to prove that the proper chain of custody was followed. In other words, there was no opportunity from the time we collected the evidence until it is presented here in court that this piece of evidence has been tampered with or has been corrupted in any way, shape, or form. Evidence must also be relevant. In other words, it has to prove the truth or falsity of some statement or declaration regarding the crime. Chain of custody needs to be carefully handled. We need to document carefully who obtained the evidence and how was this evidence obtained. In other words, was it legally obtained? Where and when was it obtained? Who obtained it? How has the possession of this evidence been controlled so that the evidence hasn't been contaminated or violated in any way, shape, or form? How is it moved? And we generally will want to segregate the duties regarding the handling of this evidence because of the potential for fraud. In other words, the defense might try to attack on the grounds that whoever obtained the evidence and maintained the evidence might have some reason that they want this prosecution to stick. So we want to see to it that not any one person is responsible from the evidence from the time it was gathered until it is presented in court. You should know the evidence life cycle. This is an important thing for you guys to know relative to the CISSP certification exam. First, we discover the evidence. Then we protect it, make sure it doesn't get compromised. We take photographs or movies of the evidence in its original location before moving it. Then we collect the evidence and we identify it with labeling. We also generally will put it in a sealed container so that we can protect it from contamination. We now transport this evidence to a place where we can analyze it. We will not perform analysis on site typically. We take it to a forensics lab where there's highly trained, specialized professionals in forensic investigation, and they are aware of proper procedures on how to not contaminate the evidence. After we've learned everything we can from the analysis of the evidence, we have to store it until the time of the trial. That requires storage and preservation, and then of course we have to transport the evidence to the courthouse. Then the evidence is presented in court, and eventually the evidence will be returned back to the owner. Again, you should understand all elements in this evidence life cycle. One type of evidence that you should be aware of is called hearsay evidence. Hearsay evidence is not generally considered to be very accurate. It's not first-hand proof, and it is generally not considered to be terribly accurate. Computer-generated evidence is considered hearsay evidence. The printed version is the printed version of a document on a hard drive. The printed version is considered hearsay evidence. Now, regarding business records in hearsay evidence, as long as the documents, the business records, were collected during routine business activities, this now is worthy evidence and it is exempted from the hearsay evidence rules. So again, as long as the printed documentation from routine, regular business activities is presented in court, this is generally considered excellent evidence and it is exempted from the hearsay rule.